Judgment in the appeal of the Queen on the application Trail Riders Fellowship and another, and Dorset County Council.
Lord Clerk will explain the judgment of the court.
This appeal is about a map or maps. Under Section 53 of the Wildlife and Countryside Act 1981, as surveying authorities, local councils are required to maintain a definitive map and statement of the public rights of way in their local area. Under the 1981 Act, members of the public were entitled to apply to surveying authorities for an order modifying the definitive map and statement in the light of new evidence of the existence of a public right of way. Under Schedule 14, such applications had to be accompanied by, quote, a map drawn to the prescribed scale and showing the way or ways to which the application relates, unquote. The scale was prescribed by 1993 regulations, which provide that a definitive map must be on a scale of not less than 1 to 25,000, and that an application map, that is a map accompanying an application for a modification order, must be on the same prescribed scale. Section 67 of the Natural Environment and Rural Communities Act 2006 extinguished all unrecorded rights of way for mechanically propelled vehicles in England as of 2nd May 2006. However, such rights of way would be preserved if an application for a modification order was made before the 20th of January 2005. Section 67(6) specifies that such an application is made when it is made in accordance with paragraph 1 of Schedule 14. Before the deadline, on the 14th July 2004, the Friends of Dorset's Rights of Way made 5 applications to Dorset County Council, the appellant, under the 1981 Act, for orders modifying the definitive map and statement to show various byways open to all traffic known as boats. The application maps were produced using a computer program which printed out maps to a presented scale of 1 to 25,000 or larger, which was derived originally from Ordnance Survey 1 to 50,000 maps. The Trail Riders Fellowship, now the first respondent, is now the first respondent. Over 6 years later, on the 7th of October 2010, the Council rejected all the applications on the basis that the application maps were not drawn to a scale of not less than 1 to 25,000. If the Council's decision is upheld, the vehicular rights of way in question will no longer exist. The judge, Mr. Justice Supperstone, upheld the Council's decision on the principal basis that the application maps did not comply with the statutory requirements. Led by Lord Justice Maurice Kay, the Court of Appeal allowed the appeal, holding that the application maps did comply with the statutory requirements. By a majority of 3 to 2, the Supreme Court dismisses the appeal on that point and upholds the Court of Appeal's decision that the maps complied with the statutory requirements. I give the leading judgment, with which Lord Toulson and Lord Carnworth agree, giving concurring judgments of their own. Lord Sumption and Lord Newburger would have both have decided the point the other way. The only question is whether the application maps were drawn to a scale of not less than 1 to 25,000. The majority concludes that they were. Each map was in fact produced to a presented scale of 1 to 25,000 or larger. The statute and regulations could have, but did not, require that a map with the amount of detail of an Ordnance Survey 1 to 25,000 map be used. And the mere fact that one might ordinarily expect the use of an Ordnance Survey 1 to 25,000 map does not tell us whether that is a legal requirement. Maps drawn to a scale of 1 to 25,000, without any reference at all to an Ordnance Survey map, would satisfy the statutory provisions, even if they contained only as much detail as an Ordnance Survey 1 to 50,000 map. Although the prescribed scale requirement applies to the application map and to the definitive map and in the same terms, it is important to note that the surveying authority is under a public law duty to prepare and maintain the definitive map and statement to a professional standard, whereas lay applicants are only required to put relevant material before the surveying authority for investigation. Moreover, a map could be drawn by a computer program. It follows that the appeal fails by a majority on ground 1 and that the second ground does not arise, so there's no need for me to address it now.
Thank you.
The court is now adjourned.